case briefs, and so much more. LSData's got what you're looking for.
The United States Court of Appeals for the District of Columbia Circuit heard the 1990 case, Western Maryland Railway Company v. Harbor Insurance. The case centered on Rule 19 of the Federal Rules of Civil Procedure, which stipulates that absent parties in federal lawsuits need only to be joined as necessary and indispensable parties. The court must also consider whether complete relief can be granted without their involvement, and whether parties would face a substantial risk of inconsistent obligations if they were not joined. The case began when railroad employees exposed to asbestos filed claims under the Federal Employers' Liability Act, FELA. The railroads in question then sued their insurers for damages and to clarify their rights under policies with aggregate limits. However, the district court dismissed the cases on the basis that the absent parties, the employees who had filed the asbestos claims, were not considered necessary. The Court of Appeals disagreed and examined rules surrounding the addition of non-parties and the possible inconsistencies in insurers' obligations. In their analysis, the court found that while the railroads were not necessary parties, the absence of the employees did not put the insurers' obligations under the aggregate limits at risk. Consequently, the court reversed and remanded the case. The Court of Appeals ultimately held that the district court's dismissal of the cases was incorrect, reversing the decision and remanding the actions for proceedings consistent with their opinion. The district court was required to join absent parties under Rule 19, A2H, to avoid exposing insurers to inconsistent obligations. The cases continued in federal court since parties obtained jurisdiction by colluding not to join.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of climb.